for evidence to be admissible, kailangan siya is relevant and not excluded by this rule, no? Or not excluded by the law. No, ibig sabihin may kinalaman siya dun sa fact in issue or dun sa issue or dun sa krimen, no? And dapat is legally acquired, no? And next, yung relevancy of and yung collateral matters. Yan. Evidence must have such relation in fact in issue. And may nag-join. Fact in issue as to induce belief in the existence or non-existent. Yan po yung sinasabi natin, no? Eh kapag po kasi collateral matters, no? Hindi po kasi siya allowed, no? As a general rule, hindi po tinatanggap itong mga collateral matters. No, ibig sabihin may relasyon siya dun sa fact and issue but hindi directly na pinapatunayan, no? Exception when it tends in any reasonable degree to establish the probability of the facts in issue. And ano ba yung example nitong collateral matter? Halimbawa, ano bang kaso maganda? Rape, no? Halimbawa sa rape. Tapos sasabihin natin, papatunayan natin, inakit po kasi ng biktima yung ano, no? Dahil sa kanyang kasuotan, no? Yung pong considered yon or yung kanyang kasuotan or yung kanyang galaw, no? Eh hindi po yung tatanggapin as or hindi yun pwede gamitin as evidence ng pang-aakit, no? Kasi nga first, yung kaso is rape and wala or malayo yung seduction sa rape, no? Kaya hindi po yun yung tatanggapin. But kung yung collateral matter, halimbawa nga nilasing muna, no? Halimbawa nilasing po ako para bago ako pinagsamantalahan, no? Ibig sabihin malayo or hindi naman mapapatunayan, no, na dahil sa kalasingan kaya siya na-rape. Or malayo ang gusto kasi or yung tawag dito yung factum probandum natin na hinahanap is rape, no? But yung papatunayan ni collateral matters is nalasing, no? Collateral matters or hindi siya connected dun sa rape but meron siyang pwede siyang may patunay or konektado doon sa fact. Doon lang siya pwedeng tanggapin ng korte. No? And two requisite for admissibility. Yung relevance nga, ayan, umulit na tayo kanina, no? And relevance determined by rule of logic and human experience, but none but facts having rational probative value are admissible. Ayan, malalaman naman natin yan, no? Kailan ba natin malalaman na relevant? No? Based on our experience or base doon sa kaso, no? Yun po yung magdedetermine ng relevancy ng isang evidence. And yung competence, determined by prevailing the exclusionary rules of evidence. And all facts having rational probative value are admissible unless a specific rule forbid their admission. And therefore, admissibility is an affair of logic and law. No, kasi kahit yun ay connected, kung yun naman ay pinagbabawal ng batas, wala, no? Or kahit good sa batas or pwede yun maging evidence kung hindi naman connected dun sa issue, eh hindi pa rin siya tatanggapin. Kaya po, si admissibility is a combination of logic and law. And admissibility, pag sinabi nating admissibility, no, determined at the time it is offered to the court. Doon pa lang po malalaman, doon pa lang madedetermine kung admissible or kung pwede bang gamitin yung isang ebidensya doon sa issue. And object evidence offered. Ayan, ito naman po, kailan ba natin i-offered, no? Offered when presented for the court's view or evaluation. Ayan, mismo pong sa trial to in-offered, no? Habang nagta-trial, ayan, mag-offer kayo ng mga ebidensya. Ayan, and yung korte ang magdedetermine kung papayagan niya yun, no? I-admit as evidence. And pag si object, ino-offered siya kapag ipepresenta na natin sa kanila or ipepresenta na to sa korte. And si testimonial evidence naman, offered by calling out the witness to the stand. Yan, ino-offered ko siya sa korte, no? Yung pagtatawagin na. Madalas yan, yung tatawag niyan, yung attorney, no? Maaari ko bang tawagin si ganito para tumayo dito sa ating witness stand? And next is documentary evidence, formally offered by the proponent immediately before he rests in case. Yan, si documents naman, no? Kung si object at saka si testimonial, ipinepresenta muna natin sa court, no? Bago natin sila magamit. Ayan, si documentary evidence po, no? Pagkatapos niyang magpaliwanag ng magpaliwanag, and nag-end na yung kanyang explanation, doon niya palang pwede i-offer or i-abot kay judge yung document. No? And next, objection to admissibility. Made at the time such evidence is offered or as soon as the objection to the admissibility shall have become apparent. Otherwise, it is waived. Yan, ito pong objection to admissibility, no? Iginagawa to ng adverse party. Kapag sa tingin nila, yung evidence na ipe-present ng kanilang kalaban, hindi dapat, no? Or hindi dapat gamiting evidence. Halimbawa, si A, no? Sabi niya, si attorney A, tinawag niya si Pedro. Ayan. Your Honor, at pwede ko bang tawagin para tumayong witness si Pedro para sa aking kliyente. No, ngayon, si attorney B, sasabihin niya, objection, Your Honor. Si Pedro ho ay hindi tawag dito, hindi qualified as a witness dahil siya ay bulag, pipi at bingi. No? Doon po tayo or doon po ino-offer or doon ka pwedeng mag-object ng admissibility ng evidence, no? Kapag or habang ito ay ino-offer. Next, conditional admissibility. And where the evidence at the time it is offered appears to be immaterial or irrelevant unless it is connected with the other facts to be subsequently proved, such as evidence may be received on the condition that the other facts will prove thereafter, otherwise the evidence will be stricken out. Yan, itong mga conditional admissibility, no? Para nga rin doon sa parang sa collateral, no? Ang pagkakaiba lang nito, ito is hindi talaga pwedeng tanggapin ng korte. But dahil magaling yung abogado, sabi niya, pwede niyo po itong tanggapin as conditional admissibility. Dahil kapag napatunayan namin na itong bagay na to ay nag-exist, magiging ebidensya to. No? And by that, tatanggapin nyo ng korte until mapatunayan or matapos yung trial and mapatunayan dapat ng nag-offer yung conditional admissibility, no? Yung sinasabi niyang proof. And kung hindi, edi tatapyasin or hindi na yung tatanggapin or i-striken out na yon, no? And next is qualification. And no bad faith on the part of the proponent. It is necessary to avoid unfair surprises to the other party. Yan, ibig sabihin, kaya lang ginagawa itong si conditional admissibility, no? Para kung wala naman, kung intention naman po ng proponent or nung nagsiserve ng evidence or yung nag-offer ng evidence, para nga lang hindi masurpresa na meron na pala silang ganon na ebidensya, no? Yung kabilang party. And next, multiple admissibility, where the evidence is relevant and competent for two or more purposes. Such evidence should be admitted for any and all purposes for which it is offered, provided it satisfies all the requirements of the law for its admissibility. Yan, ito pong si multiple admissibility, no? Kung yung isang ebidensya ay nagpapatunay ng dalawa or higit pang facts, no? Pwede niyo siya ulit gamitin as evidence. 'Di ba? Halimbawa, yung kutsilyo. Ayan. Pinapatunayan ng kutsilyo or yung kutsilyong may dugo na yung dugong yun ay dugo ng suspect dahil sa DNA. And at the same time, yung kutsilyo is merong fingerprint ng suspect. No? Ibig sabihin, pwede yun maging or pwede yun i-admit as proof na yung kutsilyong yun ay ginamit as murder weapon and as means of identifying the suspect. Okay? And next, curative admissibility. Threats upon the right of the party to introduce incompetent evidence in his behalf where the court has admitted the same kind of evidence of the adverse party. Ayan, dito po kasi yan, no? Dito sa conditional admissibility. Kasi nga si conditional hindi pa siya competent. No? And by that, pinapayagan din ng korte yung kalaban nila na mag-submit ng same type or incompetent din na evidence. And tinatawag na nila yon na curative admissibility. And yun po is para maging patas, no? Para maging patas yung korte. And next, juris. Ito mga juris niyang admissibility. American rule. Admission of incompetence evidence without objection by the opponent does not justify opponent in rebutting it by similar incompetent evidence. Ayan. Sa American rule po, no? Kapag ikaw ay nag-present ng incompetent evidence and walang objection na nangyari, no? Hindi in-object ng kalaban. Ayan, hindi po meaning nun or hindi ka po papayagan ng korte na or yung kayo ay hindi kayo papayagan na mag-admit din, no? Kasi kung ma-object yun ng kabila. No? And yung English rule, if a party has presented inadmissible evidence, the adverse party may resort to similar incompetent evidence. Ayan, yun yung parang ginagamit natin, no, yung English rule at saka itong Massachusetts rule. An adverse party may be permitted to introduce similar incompetent evidence in order to avoid plain and unfair prejudice caused by admission of the other parties. Next, former rule. Ito po yung dating rule, no? Illegal or illegally obtained evidence still admissible unless specifically forbidden. But doon sa kaso po ni Stonehill versus Jock, no? It was ruled that documentary evidence illegally obtained is inadmissible on a timely motion or action to suppress. Actually, no, ngayon nga, meron na tayo nung kapag illegal mo nga nakuha yung ebidensya, kahit hindi documentary evidence, hindi mo na siya pwedeng gamitin in any court, no? And next, collateral matters. Ayan, matters other than the facts in issue and which are offered as basis for inference as to the existence or non-existence or non-existence of fact in issue. And next, dito na tayo. What need not to be proven? Kung Rule 129. And dito po, no? Dito natin maano tong judicial notice. Pag sinabi nating judicial notice, no, ito po yung mga bagay na hindi na kailangan or hindi na natin kailangan magbigay ng ebidensya or mag-present ng evidence sa korte para paniwalaan ng korte. No? And siya is magiging mandatory na mag-take ng judicial notice ang court when a court shall take judicial notice without the introduction of evidence of the existence and territorial extent of state. Ayan, yung mga kung gaano kahaba or kalaki, no, yung territory ng isang lugar and extend their political history. Yan, kasama po forms of government and symbol of nationality, the law of nations, the admiralty and maritime courts of the world and their seal, the politic, constitution and history of the Philippines, the official acts of legislative, executive and judicial departments of the Philippines, the laws of nature, the measure of time, and the geographical division. Yan, yung pong lahat ng nabanggit ko, no? Automatic po yun. Hindi na natin kailangan ng ebidensya kung papatunayan natin sa korte. Halimbawa, no? Yung gusto natin patunayan sa korte na si Rizal, yung pambansang bayani. And ayon sa history ng Pilipinas, no, na si Rizal nga ang pambansang bayani, no need na magbigay ng ebidensya. And next, judicial notice when discretionary. Yan, ibig sabihin is depende sa korte kung tatanggapin niya yon without evidence or not. And a court may take judicial notice of matters. Yan, napansin niyo, no, dito, a court may take. Samantalang dito sa una, a court shall take. Kasi nga mandatory. And number 2, ayan, judicial notice of matter which are public knowledge or are capable to unquestionable demonstration or ought to be known to the judges because of their judicial function. Yung mga public knowledge, no, or yung alam naman ng lahat yung bagay na yon, hindi na pwede or pwede nang hindi magbigay ng ebidensya. No, halimbawa, sabihin natin na madilim po kasi sa lugar na yon, no? Hindi na natin kailangan picturean kung gabi naman talaga nangyari at saka liblib na lugar, no? And ayun. Next po is judicial notice when hearing necessary. During trial, the court on its own initiative or on request of party may announce its intention to take judicial notice of any matter and allow the parties to be heard thereon. After the trial and before judgment or an appeal, the proper court on its own initiative or on request of a party may take judicial notice of any matter and allow the parties to be heard thereon if such matter is decisive of materials issue in the case. Ayan, paiksiin natin, no? Kapag po yung tawag dito, judicial notice, parang nakakalito, no? Or hindi kumpleto or parang duda, no? Duda si judge na pwedeng i-take as judicial notice, magkakaroon po ng hearing. No? Sasabihin ng korte, sige, ipaliwanag mo muna sa akin kung bakit yan naging isang or bakit yan pwedeng tanggapin as judicial notice. Yan, pwedeng yung court mismo yung magsabi and pwede din naman yung adverse party or yung kalaban. No? Kung hindi rin nila naiintindihan yon. And ayun. And next is, ayan, mga ano na to, definition of terms. Judicial notice, cognizance of certain facts which judge may properly take and act on without proof because they already know them. Courts are required to take judicial notice of laws. Ayan, automatic yan, no? Yung mga batas, hindi na natin kailangan magpakita or ipakita sa korte. Ito po, yung batas na nagsasabing ganyan, no? Expect na natin or expectation na or expect na natin sa judge na alam niya yon, no? And courts are required to take judicial notice of the decision of appellate courts but not of the decision of the coordinate courts. Ayan, ibig sabihin po, no? Yung lahat ng korte, kapag ang desisyon ni appellate court na itaas yung kaso, hindi po yun pwedeng tanggihan, no? Required po ang judicial or ang susunod na korte or yung mas mataas na korte na i-accept yung kasong yun, no? But sabi dito, but not the decision of coordinate courts. Ayan, halimbawa, yung decision ni MTC is guilty. No, pwede po yung hindi tanggapin or mag-iba pagdating kay RTC. Okay?
Sir, paano yung natataas sa mas mataas na court?
Ayun po, kaya matataas po 'yon pag pumunta or mag-aapila tayo, no, sa appellate courts. Once na yung appeal natin ma-approve, ayun po, doon po magsisimula ulit yung kaso sa mas mataas na korte. No, hanggang makarating ng Supreme Court kung madami-dami talaga kayong pera. Ayan, saan nyo ba napag-aralan dapat to? Sa criminal procedure. May criminal procedure ba kayo ngayon?
Wala pa.
Wala, sir.
Wala. Kailan nyo ba pag-aralan yung crim pro? Well, hindi nyo pa natitake kahit ng third year?
Tapos na po, sir.
O, di ba? Tapos na yung criminal procedure. Doon yung pinag-aralan nyo na. Pagkatapos ng isang trial, meron kang 15 days to appeal, to file an appeal. Susumbong ko kayo kay Ma'am Pabi.
Si Ma'am Ikawat po ata yung amin, sir, nun.
Si Ma'am Ikawat.
Tanda ko na.
Si Ma'am Ikawat ang nagturo sa inyo ng Crim Pro. Susumbong ko rin kayo kay Ma'am Ika. Sinong section ba to? 4-1.
Ako, huwag mo ko sumbong.
Si Dakoro po, Ma'am.
Sir, naalala ko ako nagsabi sa iyo eh.
Ikaw ba? Sige. Okay, next, judicial admission. Yan, ito po yung pag-amin, no? Kung nasanay tayo dun sa investigation, ano natin ang investigation ng confession and extrajudicial admission. Ayan, dito naman po sa evidence, yung judicial admission or yung pag-amin sa korte while on trial, no? An admission, verbal or written, made by party in the course of the proceeding, in some case does not require proof. Yan, ito pang isa, no? Itong judicial admission. Kung inamin mo na sa korte yung ginawa mo, no? Hindi na kailangan ng patunay. And the admission may be contradicted only by showing that it was made through palpable mistake or that no such admission was made. Yan, pwede lang kontrahin. Sabi, Your Honor, nagkamali lang pala ako. Ito pala yung gusto kong aminin. Hindi yan, no? And ayun, kapag umamin, automatic, ayun na yun, no? Unless mapaliwanag mo na nagkamali ka or iba pala yung ibig mong sabihin. No, and next, judicial admission may be made in pleadings filed by the parties, the course of trial, either by verbal or written manifestation, and other stages of judicial proceeding, and must be made in same case in which it is offered. If made in another case or in another court, must be proved as in any other fact but entitled greater weight. Ayan, ito po, no? Si judicial admission, medyo tricky siya. Halimbawa, umamin ka dun sa MTC, yon, may inamin ka. Halimbawa, inamin, opo, nandun ako sa lugar na yon, pero hindi ako yung pumatay. Inamin mo, no? Ngayon, pagdating sa RTC, nung nagkakaanuhan na, sabihin, di ba inamin mo dun sa Ayan, hindi po yun pwedeng i-consider as judicial admission agad, no? Kailangan pa patunayan na sinabi niya yon. No, dahil nga, kung maalala nyo, balik tayo dito, no? Yung courts, ayan, courts but not decision of the coordinate courts. Sabihin yung decision or yung nangyari sa mas mababang korte, hindi na ititake ni higher court. Kasi judicial admission, no, kailangan niya ulit gawin or kailangan patunayan na sinabi niya talaga yon sa korte na yon para ma-admit ulit as judicial confession. Okay? And admissibility rules, ayan, admissible, ito po, admissible unless made only for the purpose of the first case. Ayan, ibig sabihin, yung pag-amin niya, para lang dun sa naunang trial or dun sa unang kaso, no? And next is, nawala. Ayan, withdrawn with the permission of the court. Ayan, pwede po i-withdrawn or ipawalang bisa nga, 'di ba? Itong si admissibility. Kapag ikaw ay may nagkaroon ng palpable mistake or yung obvious na nagkamali ka, and kapag napatunayan mo na walang ganong admission nangyari. And next is court deem it proper to relieve the party. Yan po. And admission in pleading which have been withdrawn or superseded by an amended pleading, or it is considered an extrajudicial admission. However, the rule seems now to include superseded pleading as judicial admission. Yan. No? Kung tatanggapin man ng korte yung pag-amin mo na yon na ginawa mo sa unang kaso or sa unang trial mo, no, ng higher court, itatanggapin na lang daw yon as extrajudicial admission. But now, parang nakikita natin in reality, no, tinatanggap na rin yun. Siyempre naman, tao lang din naman yung mga judge, and alam niya na umamin na yun doon, no? Madalas, kino-considered na rin nila na judicial admission. Okay? Note, facts and facts subject of the stipulation or agreement entered into by the parties at the pre-trial of the case constitute judicial admission. Yan, yung mga napagkasunduan po, no? During pre-trial pa lang, kahit pre-trial pa lang, considered yon as judicial or judicial admission. And by them which under this section do not require proof and cannot be contradicted unless previously shown to have been made through palpable mistake. Yan, no, yung napagkasunduan nyo po doon sa pre-trial and naka-record yun, no? Ibig sabihin, hindi na kailangan ng patunay na yun yung napag-usapan nyo kay pre-trial. And next is admissibility of evidence. Yan. Object or real evidence, section 1. Yan, rule 130 na tayo. Object as evidence are those addressed to the senses of the court. And when object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. And where object is relevant to a fact, in issue, court may acquire knowledge by actually viewing the object and becomes object evidence. Ayan, no? Paano ba natin masasabing relevant? Yan. Number 1, kapag nakita na ng korte. No, kung sa tingin ng court, relevant yon, then ma-admit yon. And next is receiving testimonial evidence thereon, the fact that an ocular inspection has been held preclude a party from introducing other evidence on the same issue. Yan. Kapag daw po, no, may nagpatunay or may testimonial witness tayo na yung object evidence na yon ay talagang mahalaga or relevant, no? Lalong-lalo na kung yung testimonial evidence natin na ibibigay natin doon sa object, no, is expert witness. Halimbawa sabihin, yes po, Judge or Your Honor, mahalaga po itong object na ito dahil ito ang nagpapatunay ng ganito ganyan, no? Ayan, next. Ay, next po is yung ocular inspection. Lies within the discretion of the court, imbibed if conducted by judge without notice or presence of the party. Ayan, ito pong ocular inspection, ito na nga yung kapag piniresent si object evidence, no, yung ipapakita na sa mga tao or titingnan na ni judge or susuriin ni judge. Ayan, hindi po siya valid, no, kapag ginawa yun ni judge without yung mga or yung magkalabang panig, no? Ayun. And next, court may refuse the introduction of object evidence and rely on testimonial evidence alone if an exhibition of such object is contrary to public policy, morals, and decency. Yan, kung sa tingin ni korte, no, yung ipe-present mong object evidence ay medyo malaswa or hindi appropriate para sa public, pwede yon or sasabihin niya na wag na lang ipakita. No, kasi pag nagta-trial tayo, alam naman natin na open court yan, no? May mga nanonood. Ayan, but if view is necessary in the interest of justice, may still be exhibited. But the court may exclude the public from such view. Ayan, viewing may not be refused if the incident or immoral object constitute the very basis of criminal or civil action. Ayan, no? Kung yun talagang ebidensya or yung object evidence na yun, kailangan ipakita. And kahit siya is lumalabag na dun sa moral or dun sa tawag dito, public policy, no, or dun sa decency para ipakita sa public, ang gagawin po ni judge, ipapalabasin muna yung publiko or yung mga nanonood. At ang ititira ay yung magkalabang party lang. Okay? And next, number 2, to require its being viewed in court or in ocular inspection would result in delays, inconvenience, and expenses out of proportion to evidentiary value of such object. Yan. Kung hindi naman ganon, kabigat yung ebidensya, no? And sobrang tagal niya kung ipe-present pa kay korte, ayan, hindi na yung papayagan ng court. No? Hayaan na lang na magkaroon ng testimonial evidence or isama yun kung sino man. And number 3, such object evidence would be confusing or misleading. Yan, hindi rin po yung papayagan ng korte, no? Yung mga nakakalito. And 4, testimonial or documentary evidence already presented clearly portrays the object in question as to render in view unnecessary. Ayan, kung yung mga unang ebidensya na testimonial or documentary evidence, ipaliwanag niya ng maayos kung ano ba itong si object evidence. No? Hindi na natin yun kailangang ipakita. And next, object evidence includes any article or object which may be known or perceived by the use of any of the senses. Sight, hearing, touch, taste, or smell. Yan po, lahat po yan na nararamdaman ng ating katawan or na napipick up ng ating senses, kino-considered na object evidence. And it includes examination of anatomy of a person or any substances or substance taken their form. Yan, lahat no? Yung makikita natin yung mga dugo, ano pa ba? Kung yung katawan ng tao, no, kasama yan or considered yan as object evidence. And next, conduct of test, demonstration or experiments. Ayan, kapag gumawa tayo ng test, no, halimbawa sa isang neighborhood, no, sabihin, oh, bakit wala man lang nakarinig na nag-aaway itong dalawang to, no? Ngayon gumawa sila ng test. Your Honor, makikita nyo dito sa test na ginawa namin na kahit magsisigaw ka dito sa neighborhood na to, masyadong makapal ang mga dingding at hindi na talaga maririnig ng kapitbahay. Oh, ayan, pwede rin yun. Consider din nyo as object evidence. And next is examination of representative portrayals of object in question. Yan, considered yan as object. And observation of court may be amplified by interpretation afforded by testimonial evidence, especially by expert. Hindi yan B. Ayan, especially by expert. No? Mas bumibigat yung weight ng isang object evidence kapag may kasama siyang testimonial evidence. No, lalo nga, yung sabi ko sa inyo kanina, kung yung magbibigay ng testimonial evidence ay expert witness. The next, documents are considered object evidence if the purpose is to prove their existence or condition or the nature of handwriting thereon. Yan, ito pong mga medyo nakakalito dito kay object evidence kasi may ilan or may dalawa no, na documents na kino-considered pa rin as object evidence. Ayan, kapag si documents daw ay gagamitin natin or para sa pagpapatunay ng existence ng nature ng handwriting. No? Kung halimbawa, titingnan natin kung yung pirma ba magkaparehas or dinaya lang. No? Si documents is considered as object evidence. And next is determine the age of paper use or blemishes or alteration thereon. Ayan po, yung dalawang instances ang documents ay tinuturing as object evidence. Otherwise, considered documentary evidence. Ayan, ano ba tong documentary evidence na sinasabi natin? Ayan, si documentary evidence po, documents as evidence consists of writing or any material containing letters, words, numbers, figures, symbols, or other modes of written expression offered to prove of their content. Yan. Yung content po ni documentary evidence kasi yung pinapatunayan. No? Unlike nitong dalawa, di ba? Ang gusto nating patunayan, kung pareho yung nature and kung yung mga may nabago ba, no? May alteration ba or may mga blemish. Yan. Si documentary evidence offered as proof of their content. Ayan. And halimbawa, no, kay documentary evidence, yung last will and testament. No? Papatunayan or yung laman nun, yung gusto nating patunayan. Yun yung isang example. Ano pa ba? Yung mga deed of sale, no? Alagay doon. Pwede yan. Mga documentary evidence. And next, yung best evidence rule. Yan, ayon sa best evidence rule, yan, ito na yung section 3. Original documents must be produced. Yan, dapat daw original documents yung gagamitin as evidence. But meron tayong exception. Exception, when the suspect of inquiry in its content of documents or no evidence shall be admissible other than the original document itself except in the following cases. Yan, wala na daw or bawal daw na magbigay na ng ibang kopya, no? Except, ito lang yung exception. And when the original has been lost, destroyed, or cannot be produced in court without bad faith on the part of the offeror. Yan, kung nasira na or nawala na yung original, or kapag para makuha lang natin yung documents na yun, makagawa tayo ng krimen, no? Pinapayagan ng korte na kahit yung hindi na original document ang i-present. And pangalawang exception po kay original document is when the original document is in the custody or under control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. Ayan, no? Kung yung dokumento po ay hawak ng kalaban, no? Syempre naman, hindi niya ibibigay yun basta-basta sa inyo. And yun. And next, letter C. So, pang isang exception, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time and facts so to be established from them is only general result of the whole. Yan, no? Gaya nga nung kanina, kung masyadong mahabang oras yung kakainin para lang ma-present yung buong documentary evidence, kahit yung summary na lang nun, no? Or yung point na lang or yung pinupunto nung documents. And next is when the original is public record in custody of public officer or is recorded in public office. Yan, yung mga public records po, no? Kapag yan po yung kailangan nating i-present as evidence, okay lang po kahit yung copy na lang nito, kahit hindi na yung original. Okay? And next, section 4, original document. Yan, kailan ba natin nasasabi na ang isang document ay original? The original of a document is one, the content in which are the subject of inquiry. No, ibig sabihin, yung original document daw is yung mismong hinahanapan natin kung ano ba yung laman niya. And number 2 or letter B, para masabi nating original document, when document is in 2 or more copies executed at or about the same time with identical contents, all such copies are equally regarded as original. Yan, may mga libro kasi minsan or may mga documents, no? Kahit yung mga kontrata, kadalasan naman yan, hindi isang kopya lang, no? 2 or 3 kopya. Kung sabay-sabay naman siyang ginawa, no? At the same time, ayan, or magkakasunod na oras siyang ginawa, no? Considered po lahat yung copy na yon as original. And letter C, when entry is repeated in regular course of business, one being copied from another at or near the time of transaction, all the entries are likewise equally regarded as originals. Yan, no? Kapag naman in course of business, no, halimbawa, ito yung sa inyo, yung reg form nyo, no? Ulit lang naman yun, parehas lang naman yun. No, but 2 copy yung nakukuha nyo sa umpisa and ipapasa nyo yung isa sa registrar. And yun daw po is parehas or regarded parehas as original. And next, document refers to any deed, instrument, or other duly authorized paper by which something is proved, evidence, or set forth. Ayan. Best evidence rule or rule of exclusion. And secondary evidence cannot inceptively be introduced as original writing itself and itself must be produced in court. Yan, ito pong as a general rule nga, no, sa best evidence. Si secondary evidence is hindi pwedeng gamitin. Or kung pwede man, hindi siya mako-considered as original evidence. And next, ayan, non-production of original document unless justify under Section 3 give rise to the presumption of suppression of evidence. Ayan, no? Kapag hindi po natin or wala doon sa dahilan sa Section 3 kung bakit hindi natin mabigay si original documents, ayan, siya po is mai-exclude, no, or hindi tatanggapin. Diba? Kasi hindi natin ma-produce si original documents ng walang sapat na dahilan. No? And number 3, ng rule of exclusion, na hindi tatanggapin na ebidensya, applies only when the content of such document is subject of inquiry. And next, in criminal cases, where the issue is not only with respect to the contents of the document, but also as whether such document actually existed, with the participation therein as imputed to the accused, the original itself must be presented. Ito yung ilang example. Ayan, libel in newspaper. Ayan, diba? Criminal case po ang libel. Ayan, ngayon, ang kailangan nating i-present sa court ay yung copy ng newspaper. And yung copy na yon, di ba, is considered pa rin as original dahil sabay-sabay sila or at the same time lang sila pare-parehas na nagawa, no, or ginawa. Ito pa isa, no, yung falsification of document. Yan, ang kailangan natin dito is yung original document mismo. Kasi paano natin masasabi na na-falsify yung isang document, no, kung hindi natin makikita yung original. And next, ito po is does not apply if transaction has been recorded in writing but the contents of such writing are not subject of inquiry. Affidavits and deposition. Ayan po. Ayan yung madalas na in writing, no? Strictly speaking, the best evidence rule does not apply but will not be admitted if the affiants and the deponents are available as witnesses. Ayan, no? Sa mga written po na tawag dito, ayan yung mga written documents, yung mga libawa nga, yung affidavits and deposition, no? Hindi po siya tinatanggap as document. Lalong-lalo na kung available naman si affiant and deponents, ibig sabihin yung gumawa mismo ng affidavit or yung deposition, available naman para maging witness. Hindi po tatanggapin ni korte yan, no? And next, a signed or note, ayan, note, take note, a signed carbon copy or duplicate of document executed at the same time as the original is known as duplicate original and may be introduced in evidence without accounting for non-production of original. Ayan, yung mga carbon copy po, no, kino-considered po siya as duplicate original. Ibig sabihin, yung weight niya at saka yung weight ng original is parehas lang. Okay? And with respect to the documents prepared in several copies, through the use of carbon sheet, Supreme Court has held that each carbon copy is considered an original, provided that the writing of a contract upon the outside sheet and including the signature of the party so to be charged thereby. Now, provided yung kanyang pirma, no, or pipirmahan niya lahat yung copy na yon, no, lahat yung carbon copy na yon ipipirmahan niya. Yan po. And ayun, thereby, and dapat daw it produces a facsimile upon the sheet beneath such signature being thus reproduced by the same stroke of pen which made the surface or exposed impression. Yan, ibig sabihin, dapat, syempre dahil nga carbon copy yun, katulad na katulad, no? Kahit yung mga stroke, walang pinagkaiba doon sa nasa taas and yung nasa ilalim niya. No? And next, however, even if said signature on each copy was written through separate acts all of carbon copies are regarded as original if each copy was intended as a repository of the same legal act of the party thereto. No? Ayan, kino-consider daw siyang original. Kung yun naman daw is parehas yung or iisa yung purpose nun ng mga kopya na yun. And next, yung imperfect carbon copies is, ayan, pag imperfect, no? Kasi sabi nga dito, dapat is facsimile. Ayan, ibig sabihin po, parehas na parehas. Ayan, kapag imperfect, ayan, medyo malabo yung carbon copy, baka hindi masyadong napadiin yung pagsulat, no? Imbis na maging original document, is ituturing lang siya as secondary evidence. Ayan, tatanggapin lang, no? Kung matatandaan nyo dun sa best evidence rule, tatanggapin lang si secondary evidence kapag hindi na ma-produce si original. Okay? And section or number 2, section 5, itong secondary evidence. When the original document is unavailable or when the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its content by a copy or by a recital of its content in some authentic documents or by the testimony of witness in order stated. Yan, no? Kapag napatunayan po, itong si secondary evidence, no? Napatunayan na hindi na talaga mapuproduce itong si original evidence. Ayan, pwede po tanggapin si secondary evidence. And yun yung magpapatunay, no? Dun sa laman ng original evidence. And ito po, pwedeng yung copy or pwede, kung kabisado mo naman, no? Yung i-recite mo na lang kung ano yung laman nun. Or kung merong witness, nakakita, nakakaalam kung ano yung laman ng documentary evidence mo na yun, eh pwedeng siya din, no? Or yun din yung mag-present nun as evidence. And next, requisites. Ayan, proof by satisfactory evidence of. Ayan, yung execution of original, ayan, prove through the testimony of either person who executed it, person before whom execution was acknowledged, or any person who was at present and saw it executed and delivered, or who therefore thereafter saw it and recognized the signature, or the one to whom the parties thereto had previously confessed the execution thereof. Ayan, no, para mapatunayan daw ang isang original documents. Ito po yung kailangang mga testimony. Una, siyempre, kung sino yung may gawa nun. Diba? Ikaw yung may gawa nun kaya alam mo kung yun ang original or hindi. Pangalawa, pwede din naman yung tao, no? Person before whom is execution was acknowledged. Ibig sabihin yung pinagsabihan or yung nakakaalam na yung document na yon ay ginawa. No? Yan po yung mga pwede. And yung C, medyo madami. No? Yung mga tao or yung mga naka-witness ng paggawa nun, yan, pwede din. Or yung nakakakilala dun sa sulat or dun sa signature, no, ng documents na yon, pwede din. And ayun, yung mga taong nasabihan or ayun nga, pinagsabihan ng tungkol dun sa documents na yon. Ayan po, ang mga pwedeng magsabi or maging patunay na ang isang documents ay original. And 2, loss, destruction, or unavailability of all such original, not due to bad faith, intentional destruction of origins by party, who, however, had acted in good faith, does not preclude his introduction of secondary evidence of the contents thereof. Yan, no? Kung yung original, ikaw mismo yung nakawala or ikaw mismo yung nakasira. But, not in bad faith. Ibig sabihin, hindi mo naman sinasadya or hindi mo naman gustong sirain, no? Or hindi naman intentional yung pagsira mo dun sa document. Halimbawa, yung titulo ng lupa, ayan, nasira or ginaga dun sa pinagtataguan mo. No? Ayun, ibig sabihin, hindi mo naman gustong mangyari yon, na mawala yon, yung original copy. Ngayon, ayun, doon ka papayagan na mag-introduce ng secondary evidence and may be proven by any person who A. Knew of fact of loss or distraction. Yan, kailangan may witness ka rin na magsasabi or nakakaalam na yung original documents mo ay nawala or nasira. Number 2 or letter B, had made a sufficient examination of the places where the documents or papers of similar character are usually kept by the person in whose custody the documents was and has been unable to find it. Yan, kung hinanap mo na no, dun sa mga pinagtataguan mo and hindi mo pa rin makita. Next, has made any other investigation which is sufficient to satisfy the court that the original document is indeed lost. Yan po yung mga patunay. No? And next, reasonable diligence and good faith in search or attempt to produce the original. All duplicates or counterpart must be accounted for before using copies thereof. Yan, no? So po talagang hinanap or sinubukan mong hanapin yung mga original. And yung mga duplicates kung meron man, no? Ay kung wala na talaga, doon pa lang po tayo gagamit ng mga copies. And ayun. That's the end of our discussion. Medyo lumagpas lang tayo ng konti sa oras.